one surface matter of sale auction fixed on tomorrow.
Yeah. My lord, sale auction has been fixed on tomorrow.
Pardon, Your Lordship, an eviction matter, Your Lordship.
Yes.
List item 159. Last time it was 133. Matter is urgency person of wife is in hospital. Property mortgage property is sell, but bank has returned to excess amount. Till yet, in the meantime, more than 2 years allowed, but not now. Monday, person of wife is hospitalized. Urgency is taken up. 159. Addition.
Sufficient matter on poetry on also.
Mortgage property sell already sold. Now bank has to return.
Go to the appropriate remainder of the allocation. See that, yes, next.
Last time it was coordinate bench. Directed to.
We'll see that.
Taken up tomorrow, if we not today, taken up tomorrow.
Tomorrow there is a break bench, so yes.
Monday.
Yes, it's Monday. That should be there. Monday is a holiday. Tuesday it will come. Yes.
Supplemental list, item number 1.
May I please?
Addressal notice dated 23 August 24. At page 57 is under challenge under Surface Act. But Annexure 1.
Go to the appropriate.
Again, this matter, Your Lordship may kindly appreciate. The Annexure 1 as page 22 and 23. Initially,
the हिसाब किताब जहाँ अपन पढ़िएगा
compromise amount they have already accepted.
No.
They have already accepted the compromise amount. Only my request was to twice I had lost to this honorable court, and despite the order passed by on a single judge, to calculate only.
It is very well mentioned in that Annexure 13 that you have not complied. The decision of bank has already been intimated to you by letter dated so and so. Copy of the letter is shown. You have failed to make payment in time. So your request for revival of the compromise offer with delayed period interest is not acceptable to the bank, hence declined by the higher authorities by the bank. The payment made by you to so and so have already been adjusted in the loan account.
Yes, that is why I am before your lordship. Once they have accepted the compromise amount, and subsequently also in another loan account, I have also deposited recently on 3rd August.
All right. Alternative
Monday I will approach the appropriate forum. Till then, I may be protected because 9.
We are hoping that this is not maintainable. You are at liberty. You can move and file it.
Till then,
view of the number of Supreme Court decisions, all we are quoting in this.
Because I am on deathbed. My son has shown affidavit before your lordship.
Yes, item number
2. At this situation, on 9 they will evict
Item number 2.
Dwelling house.
Item number 2, may I please, Your Lordship? Yeah. Your Lordship, in this writ petition, the petitioners are praying for the compensation towards the structural cost, as well as challenging the general eviction notice that has been passed without first considering the prayer of the petitioner towards the structural cost, Your Lordship. Your Lordship, the brief fact of the case is that the National Highway Authority of India proposed to acquire the lands near the national highways, Your Lordship, for the 4-laning of the roads. Thereafter, the landowners were paid compensation for the land. However, the structures that existed, no compensation was paid towards that. Thereafter, Your Lordship,
Annexure 3.
Yes, Your Lordship. Annexure 3, Your Lordship, is the report.
No. It is the order of the DM collector.
Yes, Your Lordship, it is the order, Your Lordship, as per which, if Your Lordship may.
So you are submitting all have been mentioned there.
Yes, Your Lordship.
Yes.
And even the valuation has been done, Your Lordship, only the same has not been disbursed. And while the matter stood thus, and the petitioner was continuously pursuing the matter, out of the blue, Your Lordship, the eviction notice has been passed against the petitioners.
You see, to come to that annexure 6, what has been written there.
That is the outcome of that tree that has come.
Yes, Your Lordship.
Read that this is to notify to all encroachers.
Yes, Your Lordship. However, Your Lordship, the petitioners are not the encroachers, and it is admitted by the authorities, Your Lordship, by the joint verification as well, in which the National Highway Authorities functionaries were also there, so also the state functionaries, Your Lordship. And it has been even suggested that the compensation may be paid. The valuation has been done. And without pursuing that, without disbursing the same, the order is dated. Your Lordship, the eviction is to be proposed to be made on 23rd August.
Come to the page number 19. 19 last paragraph and then next paragraph.
Yes, Your Lordship.
Read it out.
That in the present case,
No, next paragraph.
that the landowners have not submitted any documentary evidence before the CALA or to be the undersigned as regards any cases filed by him in any court of law towards illegal occupation and construct on houses by other persons in his right lands for eviction. Exactly my submission, Your Lordship. Thereafter, Your Lordship, that the occupiers who have constructed the structures shall not vacate the structures by any means without payment of compensation of the structures which have been assessed by the executive engineer R&B Burger and 3G proposal submitted by the CALA for approval. The undersigned also recommend for providing the value of structures to the occupiers which has been assessed by the executive engineers R&B Burger. In view of above facts and circumstances, the NHI authority may take decision for providing compensation of structures situated over the acquired lands to the persons who have constructed and in physical possession for vacation of the acquired properties immediately to enable the NHI for construction and widening of NH6 road without any problems in course of taking possession.
Then you come to annexure 4. The names of the persons find place.
Yes, Your Lordship.
So
My name is in serial 17, Your Lordship.
So you did you make a application before the authority that you are the owner having constructed area?
Yes, Your Lordship.
Where is that?
Annexure 1, Your Lordship. That is the representation, and after that also the
we
petitioner.
have already
Assessed it. Yes.
structure. So
Yes, Your Lordship.
So what happened thereafter?
Thereafter, no disbursal was made. Only the eviction notice was issued, Your Lordship.
The collector have given a positive
Yes.
report
Yes,
that it
sir.
will be paid to you, and that has also been assessed, and you are number 17.
Yes, Your Lordship.
17, it is mentioned, the khata number is mentioned, plot number is mentioned, value of the structure has been mentioned. So then what happened?
Lordship, the same has not been disbursed till date, Your Lordship. Your Lordship may see Annexure 5.
Submitted any representation that in spite of this annexure 4, where your land has been, the structure has been valued and you have not been, any such representation has been filed.
Yeah.
And you have been identified as one of the
Yes.
person.
Your Lordship,
Where is that? After annexure 1, where is your application?
after that, Your Lordship, they have been only pursuing person, Your Lordship, and Annexure 5 is.
Because now that after 1, they have identified you, your area, and the value.
Yes, Your Lordship.
So you ask for it. Because a positive order, as my lord is saying, a positive order is already there from the side of the collector that you will not be evicted unless the compensation is paid.
Yes.
So why are you worried for that?
Your Lordship, because the eviction notice.
The 22 But he should give after that.
So what is the problem? We couldn't follow you. 2022 ରେ ଆପଣଙ୍କର ନା
Identify ହେଇଛି।
ଆଇଡେଣ୍ଟିଫାଇ ହେଇଛି, ପ୍ରପର୍ଟିର ଭ୍ୟାଲୁଏସନ ହେଇଛି, କଣ ଅସୁବିଧା କଣ ହଉଛି? ଆପଣ କଣ ପାଇଁ ଆସିଲେ?
Because of this sudden eviction notice, Your Lordship.
They are to just pay the compensation. Have you not gone to receive the compensation? Then it might have been deposited.
They have not
The
paid
persons
the.
who do not come to receive the compensation in spite of notice, their compensation is deposited, and that is the procedure. And the authority will proceed for evicting. If you do not come forward, you
No, Your Lordship, with all due respect,
Already
that
this
is not
case, the
the case.
structural cost has not been paid, that is why they are claiming. Your Lordship, thought estimate has been given by the collector and you know what is the cost of the structural cost.
that is
That is already there.
pointing out. The
That is
prayer
already
is that, but it has already been
valued.
valued. Your prayer is that the structural cost over plot number so and so has not been paid to it. That is sorry. So that is the prayer.
Yes, Your Lordship.
So annexure 4 says that it has been valued.
Yes, Your Lordship.
Collector says that unless you get it, it cannot be evicted. So thereafter, after annexure 4, the notice must have been issued to you to receive the compensation.
No, Your Lordship.
And you are aware of Annexure 4.
Yes, Your Lordship.
You are not disputing the value of that. Are
No,
you
Your
disputing?
No, Your
So you are not disputing also.
No, Your Lordship, I'm not disputing. I'm only
And
saying
this,
for
this eviction order will not affect you also, because the order is very
Your
clear.
eviction has already started, Your Lordship.
You are appearing for whom?
I am for the Union of India, my lord. In item number 4,
NHA.
and item number 3, my lord, Mr. Rautra is appearing his yield.
So it's all right. We are asking him, since it has already been valued, it is to be
Disbursed only.
Yes, ma'am.
Look, the petitioner, Gangadhar Das, has filed this writ petition for a direction to the opposite parties number 1 and 2 to pay compensation to the petitioner toward the structural cost over plot number 1701 bracket P pertaining to khata number 29 of Mauja Kalapani in the district of Bargarh, which was acquired for the purpose of four-laning of Sambalpur-Bargarh Orissa/Chhattisgarh border, section NH6 in the state of Orissa. From the letter of the collector, Bargarh, dated 18/6/2019, which is addressed to General Manager Technical NHAI. It appears that the occupiers who have constructed the structure shall not vacate the structure by any means without payment of compensation of the structures which have been assessed by the executive engineer R&B Bargarh and 3G proposal submitted by the CALA for approval. And the collector has also recommended for providing the value of the structure to the occupiers, which have been assessed by the executive engineer R&B Bargarh. In the said letter, the NHAI authorities was asked to take decision for providing compensation of the structure situated over the acquired land to the persons who have constructed and in physical possession for vacation of the acquired property immediately to enable the NHI for construction and widening of NH6 road without any problem in course of taking possession. Learned counsel for the petitioner drew the attention of this court to Annexure 4, which is the valuation report submitted by the executive engineer, in which the name of the petitioner finds place at serial number 17. The plot number has been mentioned as 29 and khata number as 29. Plot number mentioned as 1701 bracket P, and the structure value has been assessed to be rupees 6 lakhs
63 lakhs, sir.
63 lakhs.
No, Your Lordship,
6 lakhs, sir. 6 lakh 38,000.
6 lakhs 38,000.
357.
63, no?
53 or 7? 7.
357, Your Lordship.
357. The Land Council for the petitioner submits that in spite of the valuation being made by the executive engineer and submitted before the NHAI authority, till date he has not received any compensation. Rather, the authorities are taking steps for vacating the petitioner from his plot. In view of the letter of the collector under Annexure 3 and Annexure 4, after hearing the Land Council for the Union of India, we direct the NHI authorities to take immediate step for payment of, since the petitioner is not disputing the value of the structure assessed by the executive engineer, immediately be paid within a period of 1 month from the date of production of the certified copy of the order. The Land Council for NHI shall also communicate the order to the concerned authorities for compliance. So similar order to be passed in the other matter.
Only the plot numbers have to be.
And serial number.
And the assessment.
Mr. Rautra in item 3.
ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ,
ମୁଁ seal ଦେଇଦେବି।
ଆପଣ ଟିପିକି ଦେଇ ଦିଅନ୍ତୁ 2, 3, 4 ରେ ତାହା ନାଁ ରାଇଟ୍ କର।
Your Lordship,
ସେଟା ବି dispose of.
if Your Lordship may kindly note that no coercive action may be taken against me.
That is to be immediately done within 1 month.
Pleasure. Your Lordship.
Just to let you start before taking steps for vacation, vacating the building.
Much obliged, Your Lordship. And Your Lordship, in opposite party number 2, Your Lordship, inadvertently, I have missed out to mention NHI, Your Lordship. If I may be allowed.
Is it a filing by
e-filing?
No, Your Lordship.
No.
Then you can correct it.
Much
The
obliged.
Land Council for the petitioner submits that they may be permitted to correct the cause title in respect of the name and paperless ଲେଖା ହେଇଛି। paperless ରେ ଆପଣ ଇଏ କରିଦିଅନ୍ତୁ ସେଇ ପେଜ ଟାକୁ ସେ ଦିଟା ପେଜ ଆଉ ଥରେ ବାହାର କରିକି ତାକୁ କରେକ୍ଟ କରିକି ଦେଇ ଦିଅନ୍ତୁ ହେଲା।
Obliged.
Permitted to correct the same and file the first title of page number 1 and here immediately during course of the day. NHI for the bracket of this party number. नहीं आगे serial सारी दियों तो तब तक पास हो।
Much obliged, Your Lordship.
Weekly list, item number 55.
Yeah, please, Lordships. In this case, the account of the petitioner has been seized by the income tax department matter. That's why he is not able to pay the installment in due course. And she undertakes under Annex 4, he will pay by March 2025. Accordingly, the bank accepted this and thereafter the petitioner deposited 5 lakhs.
I am appearing on behalf of the bank. My
Copy
has not been given.
I am solving just.
And moreover, since it is the surfacing matter, my lord, the DRT is the competent
Land Council appears for
Canara.
Canada.
Which is taken out the alternative remedy to dispose of. Yes, next.
Item number 56.
The petitioners are the villagers of Sorisha Pankar, whose land has been acquired for the purpose of construction of that Manjaro project, my lord. They have paid my compensation. That is Annex 4, my lord. But we are entitled for certain benefits from the state government as per the policy, resettlement and rehabilitation policy 2006 introduced by the government of Orissa. That has not been paid. Therefore, we have made a representation.
What is this?
Pardon, my lord?
This acquisition has taken place and notice has been issued. This annexure 5, it is in 2009.
Yes.
So you are covered by 2013 policy or 6 policy?
Well, I have stated.
No, what you have stated is not.
Yes, they have called me to receive the compensation.
Yes.
On 15/4/2009.
Right.
Yes, my lord. And we have also received.
Yes.
My lord, my grievance is not that they are not paying me the compensation. Our grievance is, my lord, that we are entitled for certain benefits under this scheme.
Submitted the representation.
Yes, my lord.
On 23/3/24.
Yes, my lord.
Any response you have received?
No, my lord.
All right. Dispose of the representation that is under Annexure 3. All right, next.
Item 57.
My lord. Since the petition order surface act, my lord, the petitioner challenged the legal order and sale certificate issued by the HDFC Bank Limited by the Annexure 1. Fact in nutshell is that the petitioner has borrowed 8 lakhs on 6/2/2020 and 7 lakhs on 31/12/2020, totaling 15 lakhs from the HDFC Bank as housing loan. At the time of sanction of this loan, the land and the building cost was valued at 32 lakhs, and accordingly 50% of the valued amount, that is 15 lakhs, has been sanctioned in favor of the petitioner. The petitioner paid EMI at the rate of 12,031 per month and paid totaling 1,32,572, and due to COVID pandemic situation, he could not pay the further amount.
You are challenging Annexure 1.
My lord.
Please come to Annexure 1.
My lord.
Read it out. Annexure 1 is at page number 25.
Since the loan account is closed,
So you come to paragraph number 1.
Yet, as mentioned and clarified in our previous correspondence by letter 24/2/2024, please note that after adjustment of the said sale consideration of 18 lakh towards the outstanding dues on 22/2/24 of your aforesaid loan account, there was still due and payable by you to HDFC an amount of 4,04,42,742 being shortfall in your loan account as on 28/2/24. Yet on 6 January, you had submitted a demand draft of 5 lakh towards the part payment of the loan amount, but failed to deposit balance dues within 15 days cooling period. We had realized the TD of 5 lakhs against your loan account, and post adjustment of the dues, a sum of 56,168 is now showing excess against the loan account. we request you to provide your bank details so that the account can be remitted to you. That since the loan account is already closed by sale of secured asset and balance payment of dues by you, there is no scope of one-time settlement in the loan account. The order passed by the Honorable High Court on the caption subject was 21/3/24 and we have closed the loan account and issued sale certificate on 22/24. Hence, with respect to representation made by you, we would like to inform you that we cannot accept the OTS proposal by you as the loan account are now stands closed. Hence, in view of above, we hereby returning check of 2 lakh along with the no dues certificate of your loan.
So your
My lord,
property has already been
in
sold.
this connection, I
Sale
beg to submit
certificate has
that
already been issued in favor of perhaps opposite party number 2, Devi Prasad Das,
my lord,
right?
my lord,
So, and your loan account has also been closed because that has been the amount which has been received by way of that sale that has been adjusted, and now after receiving the balance amount, your loan account has been closed,
my lord,
right? So how will you get back that property now?
my lord. In this connection, I submit kind attention is drawn to Annexure 6. Letter of 6/25 dated 26/12/2023, 42-44. Annexure 6, 42. I have received the notice under Rule 9(1) of Security Interest Enforcement Rule 2002 on 26/12/2023, which I have received on 3/1/2000, 26/12/2023, which I have received on 3/1/2024. This notice is, in this notice, page 43, I have been directed in the event you fail or neglect to pay the entire amount as mentioned above, within 30 days from the date of notice, the authorized officer of HDFC shall proceed to sell the mortgage property secured asset by adopting any of the following methods mentioned in Rule 8(5) of the Security Interest Enforcement Rule 2002. And hence, so you are directed to pay the amount, and
Mr. Counsel, now fact remains you have not paid. That is how it has been already sold. Sale certificate has been issued in favor of
sir, with
opposite party
reference
number
to
2.
this notice,
Yes. So rest of the
HDFC
thing, what you
shall
want, you
finally
go to the
HDFC shall
appropriate forum. We
finalize
cannot
the
enter
sale and
how much
mortgage
you have
property
paid, what is
secured
the
assets in the
outstanding,
question.
and why it was sold, why sale certificate was issued. All these things cannot look into that.
Sir,
The
sir, in obedience to this letter, I deposited rupees 5 lakhs.
so might
I
that might not have been sufficient. That is why.
Redemption notice.
Yes.
Sir, when the redemption notice is pending, in the meantime, I also approached the bank repeatedly to accept a further amount, but the bank instructed me that we have referred the matter to our head office, and on getting instructions, you will be intimated to pay the further amount. In the meantime, when they did not accept any amount, I came to Honorable Court. Honorable High Court filed Annexure 3, 30/34. Honorable Court directed me to file the OTS for one-time settlement, and accordingly, I filed the OTS proposal along with rupees 2 lakhs deposit. Page 40, 39, 40.
When the sale certificate was issued.
My lord,
when the sale certificate was issued in
Sale
favor of
certificate was issued on 20th.
this order has been passed. By
Miller,
that time, many things have been done which you might not have mentioned in the writ
Miller,
petition.
Miller, kind attention
At
is
least
drawn.
the order does not indicate that the sale has already been complete.
It
Sale
is drawn
certificate has
behind
been
my back.
issued. Otherwise, the court would not have passed
Miller,
such type of order.
Miller, it is behind my back. Kindly,
Whatever it may be.
I draw attention of Honorable Court at page 51 annexure 10.
So when that order was passed, when
they
you
have
have not
accepted-
got the correct state of affair before the court, merely the court has directed that you file OTS. So that cannot have any effect because
Miller,
by that time,
I am explaining, Miller.
sorry.
By that time, I had no idea or I had no information about the settlement of
Sale ordinarily takes place. There are so many ways that
Yes,
it is
so
to be
many ways.
advertised in, and auction date is to be then, sale is to be confirmed, then sale certificate is issued,
Miller,
and time is granted to the. So many things. It's not that if you say that I do not aware, I close my doors and windows, I just do not receive any letters. It is up to you.
Now, Miller, I just draw kind attention of Honorable Court at page 51.
All right. Heard the Learning
Page
Council
51 Annex
Petition and
10.
Council for this.
So they have concluded the sale on 26/12/2023 and accepted the auction value of
the
18 lakh.
Petitioner has filed this writ petition.
So Miller, kind attention is drawn to page 51. ସେମାନେ 26/2 ରେ ସେଲ୍ କରିକିରି ଏବଂ 18 ଲକ୍ଷ ଟଙ୍କା ସେଲ୍ ଭାଲ୍ୟୁ ନେଲା ପରେ ସେଇ 26/2 ରେ 9/1 ରେ ମତେ କେମିତି ନୋଟିସ୍ ଇସ୍ୟୁ କରୁଛନ୍ତି ରିଡମ୍ପସନ ନୋଟିସ୍
24
ରିଡମ୍ପସନ ନୋଟିସ୍ ପରେ ଅକ୍ସନ ପ୍ରୋସେସ ଆରମ୍ଭ ହବ
passed by the authorized officer opposite party number 1. The by Annexure 1. Annexure 1 reveals that the property has already been sold and the sale consideration has been adjusted toward the outstanding dues, and sale certificate has also been issued on 22/2/2024.
Sir, sale certificate, sir, prior to that it is already sold.
Mr. Counsel, it is mentioned that issued sale certificate on 22/2/2024. That is the letter of the bank.
Yes, that is the letter of the order.
Right.
Prior to that, sale certificate but
all right. The Learning Counsel for the petitioner submit the earlier approved this
And
court in
sale certificate can only be issued after the sale.
after the sale.
Sale is in the month of December.
Milord, 26/12 ରେ ସେମାନେ auctions
Mr. Counsel,
ଦେଇ ସାରିଲା ପରେ
part payment हुए तापरे तंग टाइम दियंती एतिक दिन भितरे balance payment करा तापरे all right WPC number 2 and so
consideration 26/12
Mr. Counsel, when we will stop or will you impose fine on? We have already heard you. We are passing the order. Don't disturb us. The Land Counsel for the petitioner submits that earlier the petitioner approached this court in WPC number 6609 of 2024, and an order was passed that the petitioners, while not accepting the prayer of the petitioner, the writ application was disposed of, giving liberty to the petitioner to give a concrete proposal as to the settlement of the loan account. And it was further directed that in event such an application is filed, within 2 days, the opposite party would consider the same in its proper perspective, keeping in view that the petitioner have already paid rupees 5 lakhs and dispose of the same in accordance with law and guidelines holding the field. The order clearly reveals that the opposite party number 1 was not heard, and on the very first day after hearing the Learned Counsel for the petitioner, the order was passed, and it was not brought to the notice of the court that by that time the property has already been sold and sale certificate has been issued in favor of opposite party number 2. Be that as it may, since the petitioner has alternative remedy, we are not inclined to entertain this request to dispose of. Yes, next.
Item 58.
Your manner, sorry. Annexure 3 is pending before the authorized official.
So once it is pending, they have a time limit to dispose it of.
No, my lord. Here what has happened?
Just
Under Annexure 1, that is, I know, my lord, that is not my objection.
You said you filed the 3 application. There is a time limit fixed.
But, my lord, under Annexure 3, I have filed, I have issued, I have requested them to supply the copy of certain documents. That is pending.
Just a minute.
That objection under section 33A.
Just a minute, Mr. Dar. 3A says if on receipt of the notice under subsection A, the borrower makes any representation, that is your Annexure 3.
No, madam.
Right?
That is not the representation order.
You just said that Annexure. I have filed 13.3A application.
No. I have requested them to supply certain documents enabling us to file the objection.
Yes.
Why it is written, you will also kindly see, initially they issued one 13.2 notice under Annexure 1, page 30. That is dated 20th May. There you will also kindly see at page 15, they have given the details of only 7 documents that was executed. 6 documents. Page 15 you will also kindly see Schedule B.
So the time limit fixed is that on receipt of the application from you, they have to communicate within 15 days about the same.
You will also kindly see page 15. Thereafter you will also kindly see Annexure 2 for same loan account. They issued another 13.2 notice dated 24/6.
Who is appearing?
My lord, I'm on behalf of the bank, my lord. In this case, Mr. Subrat Misra is going to conduct this case. We're not receiving the read copy. Some copy would be done,
Just now I am giving. So since there are discrepancies,
we are listing it on Monday, Tuesday.
Yes, next.
What is the name of the council?
Mr. Subrat Misra.
Mr. Mention is made on behalf of Mr. Subrat Misra, Land Council, for the submit that he has instruction to appear for the State Bank of India opposite party. The Mr. Das, Land Council for the petitioner, handed over a copy of the writ petition in court to the associate of Mr. Swanso, who seeks some time to obtain instruction in the matter, put up this matter on 10th of September, we commencing 10th September 2024. या देर प्रेयर होची जे आपण गोटे तांको जो नोटिस देले से आपण को किछि डॉक्यूमेंट मागिछन
आज्ञा मैलर आमे ता 13.2 रे नोटिस करथिलु
से नाती है कि सुनो तो ठीक है
इंस्ट्रक्शन नहीं जाई जंदी कोन इंस्ट्रक्शन नहीं जंदी
नहीं सर
कोई ना दी कोन जानले आपण रिट से कोन लिखि जंदी आपण यार कहउछन रिट पिटिशन पाई ना दी हम सामना रबिका आपण को देई देले आपण किछि जानना दी आरंभ कर देलेनी आपण 13.2 रो नोटिस पाइला परे 13.3A अनुଯାयी रिप्रेजेंटेशन दबा कथा से रिप्रेजेंटेशन फाइल करिया पई केतोडे डॉक्यूमेंट रो आवश्यकता थिबारु Annexure 3T फाइल करछन्ती इंस्ट्रक्शन नियंतु से डॉक्यूमेंट गुडा को सप्लाई कले बा सप्लाई करिया पोजीशन रे आपण अछंती कि नाही एति इंस्ट्रक्शन आणतु मंगलवार दिन टेक अप हला
Item 59.
May I please the lordships? My lord, present petitioner is a landless person who is a lessee. Rejects the proceedings started by the foreigner without any notice and giving opportunity to hearing to the present petitioner. Annexure 1, page 10 is the record of rights published in favor of the present petitioner in virtue of lease case number 19 by 2003.
No, in the resumption case, you must have been noticed.
No, nothing. Annexure 3 if the
Yes, made a representation of
reserves
election.
You have made a representation.
before the collector.
Collector.
My
All right, collector.
annexure 4.
Annexure 4 to be disposed of.
My lord, may I pray? I will file trace representation because
Okay.
the Pokemon ଭଲ ସେ ଲେଖିନି.
All right, annexure submitted, and he has filed the annexure 4. But learned counsel for the submitted that since some important aspect has not been mentioned in annexure, he may be permitted. The petitioner may be permitted to file a phrase representation before the collector from district magistrate Ganjam within a period of 2 weeks, giving all the details. In case such representation is made, the collectors are to well to dispose it of within 3 months from the date of receipt of the representation and communicate the order. Yeah, you just within 2 weeks. Next.
Item 60.
May I plead the law. The petition of the land action law, the land has been acquired by the ICO for the purpose of auxiliary fund number 3 began in the year 2011. That happened. That compensation amount has been paid in the 2014 million. So, but there is a meeting in the 29/12/2014 as per annexure 1 by the chairmanship of collector with the presence of all the members including the members of the opposite party number 3 million. There Miller kindly see page 12 million. There they decided to pay 49,000 rupees ex gratia and additional ex gratia. That is the paragraph bottom. Bottom 2 lines.
After reviewing of the rates, all members have offered their suggestions on finalization of rate. After detailed discussion in the matter, the SSL authority has agreed for a uniform land rate, so and so, only respect of so and so. ଏତିକି ହଉଛି 16% interest ହଉଛି so and so. କଣ ହେଲା
It's made a representation in the next slide.
ଦେଇନାହାନ୍ତି
ନା ଏକ୍ସେସିଆ ନା
representation ଦେଇଛନ୍ତି
ନା annexure 5
annexure 5 latest ଟା କୋଉଟା କୁହନ୍ତୁ
annexure 5
annexure 5
to the collector Jharsuguda.
The collector
Jharsuguda.
Jharsuguda opposite party number so on. Then it's to be disposed. Yes.
Item 61.
Yes, Mr. Mishra.
My lord. Versus kind permission, the petitioner humbly praised this honorable court and challenges the illegal action of the opposite party for imposition and demanding the consent fee by the GA department for in respect of to conversion of the leasehold land to freehold land. I will draw your lordship's kind attention. The petitioner, by way of Millard's successor and a title suit was filed, decree was there. Ultimately, property came to the name of the present petitioner. Annexure 1 Millard kindly have a glance.
No, you prayed for waiving that consent
fees.
Why? There must be a procedure.
Yes.
How can they waive out?
Because
Is there any provision to waive out?
Yes.
So just show us that.
Millard.
Go to straight to that.
Straight to that.
If somebody applies for conversion,
Millard.
and there is a procedure that one has to pay
And
the consent fee.
in a similar case, it is decided.
No, you come with the proposal for
Yes, kindly see page 32.
32.
It is only in case of sale and gift. If it sale or gift occurs, then consent fee will be Millard proportional.
Where is that?
Millard, can you see page 32?
Page 32.
Millard.
The consent fee charge in case of transfer of leasehold plot
by way of sales or gifts
in progress or municipal area was fixed at the same. In the meantime, 27 years have elapsed and the cost of the land on transfer of leasehold have been increased to a greater. Taking into consideration amount of the charge the government, after careful consideration, has been pleased to revise the rate of consent of the land 10 to 15% chance on the present rate of premium on transfer of this one.
So what is your case?
My case is that the property is inherited by me by way of Millard, and the GA department annexure 2 has Millard acknowledged and accepted my Millard that he is hereby mutated in favor of Srimati Nayan Prabha Thala, and the petitioner wants to convert the same without consent.
No.
Millard,
That you can.
freehold, Millard, only freehold.
Freehold is conversion.
Conversion fee I am ready to pay. But in a similar case, the Honorable Court has exempted in case when one successor is there. If he sell to builder, then consent fee builder will pay.
No. If I convert, I make my land, leasehold land to freehold. I have to pay the premium.
I will pay the premium of conversion fees.
Yes.
But so far, Millard, the consent fees is concerned. The consent fees is settled by because there is a cabinet decision was taken in 1970. And this decision was implemented. So, my can I take your lordships kindly page 27 annexure 7 it will be lordship to I may able to present my case. Annexure 7 page 27.
Annexure
7 page 27.
That is writ petition.
Writ petition judgment in similar case has been decided.
No, have you submitted any representation?
Yes.
That in view of this judgment or anything like that?
My lord, kindly see page 24 annexure 6. They have not taken any decision.
Okay, that is pending now.
That is pending, but after that a letter is issued, but it has not been referred.
It has not been
referred. My representation letter dated 10/5/2024 has not been referred. But
no, 29/4/2024 ଉପରେ ଆପଣ କିଛି response ପାଇଛନ୍ତି?
Say a letter
response is now pending according to
as your lordship.
Annexure 6 is to be disposed of. That is pending report.
Millard, this director is state come opposite party number Millard 2.
Next.
Oblige, Millard.
Item 62.
May I please your lordship? The petitioners before your lordship are the ex-members of Juvenile Justice Board Jajpur. By the Annexure 1 series, your lordship, they have been appointed and their tenure has been extended by the Annexure 2 up to August 2023, your lordship. But they have been not paid their sitting allowances for the period of February, March and August 23 and 25 sittings.
Just take notice and issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. It is put of this matter on 30th of September 2020. The Land Council for the state shall obtain instruction in the meantime. Serve an extra copy.
Lordship. Obliged.
Item 63.
My lord, the petitioner is a land house consequent upon acquisition of its land by NALCO, my lord. So, as per order of the Honorable Court, my lord, annexure, my page 27, the percentage of share was carved out by the my lord, LA collector, which is more than 57.9, page 27. Requirement is 33.13. 57.9. Page 27. Percentage of land loss to be declared as a substantial affected person as per the rehabilitation policy. One is to lose, my lord, more than 1/3 in the percentage, 33.13 total land loss. If one will losing 33.13, he will be called as substantial affected person to get the benefit under the rehabilitation policy. So my percentage is, my lord, page 27, loss 57.9.
Who has given this, sir?
My lord,
27 is?
Page 27.
No, page 27 is prepared by whom?
Prepared by the, on being instructed by the LA collector.
Okay. Nowhere
ଏଇ ଯୋଉ ତଳେ ଯୋଉ ଲେଖିଦେଇଛନ୍ତି କଣ 68, 58, 57 ଏଇଥିରୁ କହୁଛନ୍ତି?
No, ମାନେ এইটা
right side 57.9% ଯୋଉ ଲେଖା ହେଇଛି
57.9 ହଁ
more
share
than
of
one third.
share of
57.9 more than one third. କିନ୍ତୁ ସେ କିଏ ଦେଇଛି ସେଟା? Who has prepared it?
ମାଇଲଟ ଏଇଟା ହଉଛି ତାଙ୍କର ଅମିନ ଯେ ଏଲେ କଲେକ୍ଟର ଅଫିସରେ ଯେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅମିନ ମାନେ ଏଇଟା ପ୍ରେଜେଣ୍ଟଲି ମୋ ପ୍ରେୟାର ହଉଛି ଏଇଟା ଦିସ୍ ଇଜ ଇଟ୍ ଇଜ ଏନ୍ ଏଭିଡେନ୍ସ ବଟ୍ ହ୍ୱେନ୍ ଦେନ୍ annexure 5 annexure 5 page 28 so matter was remanded to the designated commissioner under land acquisition RDC Sambalpur
In 2016.
2016 ରେ 22/12 page 28 ରେ ମାଇଲଟ ସେମାନେ ମତେ ଚିଠି କଲେ annexure 7 page 31 you meet this requirement page letter dated 6/7/2020
Annexure 7
page 31 ରେ ମାଇଲଟ so ତାଙ୍କୁ query ଟା ମୁଁ meet କଲି ମାଇଲଟ annexure 8 page 32 ମାଇଲଟ ତାପରେ annexure 9 ରେ RDC ମାଇଲଟ
order କଲେ
ହଁ ମାନେ ଏଇଟା ସିମ୍ପଲ ମିଷ୍ଟେକ୍ ହେଲା ସେଇ ଟାଇମରେ ସେ ଓପନ ହାର୍ଟ ସର୍ଜରୀ ହେଇଥିଲା ସେଇ ଯୋଉ ଡେ ଅଫ କଲ୍ RDC ଅଫିସର ପ୍ରେଜେଣ୍ଟ ହେଇପାରିଲେ
37 ପଳେଇ ଆସନ୍ତୁ।
ଆଜ୍ଞା
Although petitioner Devraj Sahu has received the notice, but neither the petitioner nor his legal counsel was present on call on the scheduled date. Even if till date, the petitioner or his legal counsel has not submitted any written statement or appeared before the undersigned for disposal of the grievance petition. As such, it is clearly evident that the petitioner is not interested to dispose of the grievance petition. ତେଣୁ drop କରିଦେଲେ କଣଟା ଭୁଲ କଲେ?
No, my lord, ଏଇଠି ଟିକେ ଅଛି next page ରେ page 36 ରେ in obedience to the order of RDC
Annexure 4
page 25 it is very clear there. Second paragraph the original levy Gandharva Sahu nominated the son of Vansidhara and he got a job. However, two others of Gandharva, namely Jay Krishna and Kostuver, also subsequently made SAP and got the necessary benefit. But the petitioner, the present petitioner, who was working at Koraput district at that point of time, has not given any benefit. In this connection, the policy of Nalpur needs consideration. The policy says that SAP family will be entitled to get a service benefit in Nalpur. The family may include the everybody, his spouse, unmarried son, and unmarried daughter if there is no son. The benefit would include employment subject to vacancy, subject to requisite qualification and skill. The SAP is also entitled to nominate a person. The petitioner himself admitted that he was working at Koraput district and therefore probably he did not like to get any service benefit of Nalco. Now he claims to be included as SAP and because he is already 58 years old, wants to nominate his son. The land acquisition took place in 1982. Considered from the certificate submitted by the petitioner, whose date of birth was 1951, he would have been only 31 years old. So he could not have nominated anybody at that point of time because his son could not have been a major. So there is a term, much water has flown under the bridge. So he'll have poor of Hagonai.
No, my lord, no, my lord,
82 ମସିହା ପରେ ଆଜି ଆସି
no, my lord, ସେ RDC ଏଇଟା liberal policy ଆସିଲା my lord. Liberal policy ରେ 2007 ରେ ଏବେ ବି ପ୍ରତି in every year RPTC meeting is being conducted to consider the grievance of the left out affected persons.
ଆଉ ଗୋଟେ grievance petition ଦିଅନ୍ତୁ ଚାଲୁ ଏମିତି.
My lord, I pray ଏଇଟାକୁ ଟିକେ I will appear before the RDC.
No, that has been closed. That
another grievance petition. ଆଉ ଗୋଟେ grievance petition my lord.
22 ପୁଣି 24 ହେଇଗଲା.
No, my lord, ସେଠି surgery ହେଇଥିଲା.
Was the order dated 14/7/2022 issued by the Secretary of Office of RDC Sambalpur and for a direction to the opposite party to dispose of the grievance petition on merit, accepting the written statement submitted on 31/7/2000 and 3/8 2020 on perusal of the impugned order under Annexure 9, it reveals that the petitioner has received the notice, but neither he nor his legal counsel were present on call on the scheduled date, and till the order was passed, neither the petitioner nor the legal counsel submitted any written statement
counsel were present on call
or appeared before the undersigned for disposal of the grievance petition. And as such, it was held that the petitioner is not was interested to dispose of the grievance petition. Accordingly, the grievance petition was dropped due to non-appearance of the petitioner. The learned counsel for the state drew our attention to Annexure 4, which is the order passed by the collector and district magistrate on board dated 26/7/2012, wherein it is mentioned the original awardee A2 court कर देवे as follows कर देंगे devoid of merits कर देंगे so on. Therefore, after going through the same, we do not find any merits in the petition, which is accordingly dismissed. The petitioner is at liberty to file any application, and if the authority so likes, they can take into consideration in accordance with law. Yes.
Yeah, Lapra.
liberty.
You can, yeah, liberty is given.
Upon the alliance.
Liberty is
you are
liberty is given.
Liberty to file any application, phrase application, and it is up to the authority to consider the same in accordance with law. That's all. Yes. This is item number 63. Yes.
Item 64.
Yeah.
Set as say ଗୋଟେ ଇଏଟେ ମାଗିଥିଲା compensation ମାଗିଥିଲା by the time the compensation was awarded, he was a minor. Family ହିସାବରେ ସେ ପାଇଯାଇଥିଲେ ଇଏ major ବୋଲି କହିକିରି ଆଉ ଗୋଟେ ମାଗିଲେ, but he was minor at that time. And the family must have received it.
So which asked from the council to pass over.
Pass over.
Item 65.
65.
The petitioner's land has been acquired for expansion of National Highway 53, and notice has been issued by the Annexure 2 series 11, page 11 and 12 to receive compensation along with her co-sharers. But since the co-sharers are not cooperating to receive the compensation, I made a representation, Annexure 3 Miller, at page 30
to disburse your share.
My share, yes.
According to the provision provided, they can't.
My lord?
They cannot exclude the share.
No, the undisputed share can be that.
See the provision. That is to be determined.
Yes, that is to be determined.
Determined by collector. Where have you mentioned? Where have you given the representation?
Representation Annexure 3 Miller.
Before Tahsildar.
Before Tahsildar come land acquisition officer.
The collector. Anyway.
Yes, 30.
Annexure 3 is to be disposed. Annexure 3 not 2.
Annexure 3 the representation.
Annexure 3 to the representation that is to be disposed of. Yes. All right.
Item 66.
Beg your pardon, Your Lordship. My learned senior is unable to appear due to some personal difficulty.
Item 66.
Yes, sir.
You want adjournment?
Yes, Your Lordship.
To?
Next week.
Next week. All right.
Okay.
Item 67.
67 may I plead, my lord. It's a matter, my lord. The notice was issued under the National Highways Act, my lord. Land were acquired and amount was determined. And the petitioner objected to the same, and thereafter it was referred to the Principal Civil Court of the Court under Annexure 4, my lord. Page 19. LA reference case number 5 of 2022, that is related to LA case number 12 of 2021, and notices were issued, and I have filed my objection under NSS 6, my lord. And while the matter stood thus, my lord, opposite party number 1 filed a memo before the Principal Civil Court for withdrawal of the LA reference case to file it afresh, my lord. Basing on that memo, the order was passed for withdrawal, my lord, which is at page 28, my lord.
Who filed the memo?
Opposite party number 1.
Tahsildar.
Yes, my lord. Memo to file the LA reference case afresh, my lord, as there was some bona fide mistake
Yes,
on.
yes. Then what happened?
Thereafter, the LA reference case was not filed afresh, and notice was issued under Annex 8, my lord, page 29, for disbursement of the entire compensation amount in respect of all the course errors, my lord. But thereafter, I also again filed another joint objection to refer the matter to the Principal Civil Court, my lord. That is pending till date, my lord. My humble submission is that
Your which is pending till
Annex 10, my lord.
Annex 10.
Page 41.
That is dated 12/8/2020.
Yes.
2014.
Yes, my lord.
Okay.
But the Tehsildar, instead of filing afresh the LA reference case number, has issued the notice under Annex 8, my lord, for disbursement of the entire compensation amount.
All right. He has to dispose of that Annex 10 and take steps accordingly, right?
Yes, my lord.
All right.
That is to refer the matter.
This writ petition has been filed by so and so with a prayer for a direction right for
disposal of the
for not considering the joint objections inter alia for not considering the joint objection filed by the petitioner under Annex 10 for referring LA case number 12 of 2021 to the Principal Civil Court Deoghar. Second prayer to the and counsel for the petitioner submits that even though the joint objection was filed on 12/8/2024 before the opposite party number 1, but no steps has been taken in accordance with law. And therefore the opposite party number 1 may be directed to take expedite steps on Annex 10. Land Council for the state has no objection, considering the limited nature of so-and-so. The opposite party number 1 shall take steps in consonance with so-and-so Annex 10 in accordance with law. We have not expressed any opinion for the disposal. Yes.
My another humble prayer is that till my joint objection is considered, the amount may not be disbursed because the opposite party number has fixed on 9th of September for
disbursal.
Yes, my lord. That is my
We do not know. We are not hearing the other side. What might have happened? Nobody knows why he withdrew, why he did not file. So many things. At the admission stage, if you pass such order, there is likelihood of that we may miss something. Which
everything is on record.
Anyway, the objection has to be disposed of in accordance with law.
If
that includes.
And there is provision that in case suppose it is disbursed in favor XYZ who are not entitled to or whatever it may be, same can be recovered from that. Yes,
actually NHI
Union of India.
No, National Highway.
Because the competent authority is the Tahsildar.
Tahsildar is appointed by the
Anyway.
All right.
Oh, bless you.
Item 68.
Your Lordship, on behalf of S.K.Das, seeking for adjournment to next week.
I have to be instructed to appear on behalf of the bank.
Yeah.
They will be directed to solve the copy of the request.
Mr. Anjan Kumar Jaina and his associates by the power for opposite party number one. Opposite party. The wakalatnama is taken on record. Get a copy of the writ petition be served on Mr. Jena during course of the day. You want adjournment? Land counsel for the petitioner seeks for an adjournment.
Next.
Till next week. In this matter. In the week commencing from 10th of September 2024, indicating the name of Mr. Anjan Kumar Jena and his associates in the cause list. Copy te de diyantu writ petition.
Oh, bless you.
Item 69.
May I please do this? The petitioner is now aged about 84 years, my lord. And as before this honorable, as his land which has purchased has no, it's under the government khata, my lord. That is a challenge the annexure A by 4, my lord. In annexure A by 4, it has been clearly mentioned at page 35, my lord. Last paragraph. On perusal of a case records, it is certain that the order of a Tahsildar is in WLN has not yet been inquired by the senior officer. That's because it has not inquired by the senior officer in High Court direction.
SS, Orissa Servant Settlement Act, 1958.
It has rejected and it has been recorded in the name of.
This order was passed under which provision? Mr. Das, you said the alternative.
The similar matter has already been decided by the Honorable Chief Justice, my lord. That is, in case of Nodini Narottam Ratha and State of Orissa, it has already been decided, and the matter is subject before the Supreme Court now.
42A, madam. That was passed by ASO? In that case?
The additional sub-collector, madam.
No, the case which Land Council is referring to
is passed by the additional sub-collector. So against that, 42A, my lord.
So that is how the one that is being referred to by Land Council is not covered a matter. In Narottam case, it was the order passed by the ASO.
Yes, assistant settlement.
Yes, here the case is different.
But the issue is the same, my lord. The issue governing the matter is the same.
Which provision is there?
42 is the appeal, my lord. It was by
42, the 42 of
42A, my lord. Odisha Survey Settlement Act, my lord.
42A.
Sorry, my lord.
This is 9.
Yes.
Rule term.
Manual.
It's a manual.
Manual is rule type.
And here the data check. So this order has been passed under section 42, right? In the appeal, it has been passed. So the collector, 42A says that the collector may, on his own motion or otherwise, call for or examine the records of any proceeding in which orders have been passed under rule so and so 42 bita include. So that is what he is pointing out. But
the facts what has been decided by the Honorable Chief Justice, that is very much similar facts.
No. Please come to that order, annexure 4,
Yeah.
and see in the top what has been mentioned
Yes.
there. This is an appeal under
Appeal.
section
22 to
22(2)(b).
B of so and so. So what is that? 1958. Section হচ্ছে 22C.
22 to B of the
Service.
That is the 22 remainder. The settlement officer shall of his own motion or
So,
be appeal against that particular on application without 30 days from the order passed
Without no, within.
how within 30 days from the order passed on an objection preferred under subsection 1 of section 21 have power to modify any such order. The settlement officer may sanction the said rule with or
25 টা revision by 4.
22 টা sanction of settled grant and modification of order passed by an objection. সেটা এএসও পাস করে যা করিব তা এগেইনস্ট অপিলে আসলা কেতালে
Hmm. 22 to 25 seven. Against 22(2), it is 25 revisions. So much revisional power or they will finally
So revision means in any case on its own method at any time after the date of final publication of the section 23. All on application made 1 year the said date directly revision and most of the
amended instruction. The revision depends upon filing of objection under section 22(2)(b). Section 24 provides for so much of that. The commission has taken the stand that B section 25 as amended. 25 has been amended.
Yes.
have you got this the memo of that appeal case? Appeal memo ଅଛି କି ଆପଣଙ୍କ ପାଖରେ ଯୋଉଟା ଫାଇଲ କରିଥିଲେ
ନାଇଁ ସେଟା ନାହିଁ
22(2)(b) ରେ
ସେ ଅପିଲ ଗୋଟେ ନାହିଁ ଏଇଟା ମାରୁଛୁ
since it was a code of review final publication for it
25 record.
ବର୍ତ୍ତମାନ ଯଦି ଇଏ କରିଦେଇଛି ସେ ଅର୍ଡରଟା ତାପରେ ଏଇ ଯୋଉ final publication ହେଲାନି କି ନାହିଁ
23.
so whether it has been finally published as per section 23.
I have no idea about it.
Yeah.
Then how can you
The organization of the business is directly
No, that is on your case, what on your case, what appears. Yes, the thing. The application has been initiated based on the petition along with the copy of it. You produce your petition, you come to that order dated 22/4/2021. Come to page number 33.
36.
Come
33.
33. Fourth line from the top. Please read it out.
The appellant case has been initiated basing on the petition along with the copies of documents submitted by the appellant to record the following schedule of land in his paper.
So where are those copies and of that petition along with the documents?
I'll produce it. I'll produce it.
So this order was passed in 2021. 22/2020 এটা যদি 22/2B ରେ ପାସ୍ ହେଇଛି ଏବଂ ହେଲା ପରେ then next provision ଆସୁଛି final publication. ତେଣୁ final publication ର position କଣ?
ମୁଁ ଜାଣିନି।
ଜାଣିନାହାନ୍ତି okay then how instruction ନେଇକି ଆସୁ the Land and Council for the petitioner seeks some time to obtain instruction as to whether after the impugned order dated 22/4/2021 has been passed by the additional sub-collector Bhubaneswar in appeal case number 88 of 2016 by Annexure 4. Whether any final publication as contemplated under section 23 of the Odisha Survey Settlement Act 1958 has been made or not. Put up this matter in the week commencing from 17th of September 2024.
69 and 70 were both. 69 and 70 both.
Same.
Yes.
Item 71.
Yeah, please fill up the slide. Petitioners before your lordships are the erstwhile directors of the company, my lord, who is the pro forma opposite party before your lordships. Now the pro forma opposite party had obtained a loan from Canada Bank notes, and due to certain problems, my lord, there was a default in payment of the dues, my lord. And subsequently, when actions could be taken by the bank, I offered for an OTS. The OTS proposal was accepted, but due to the backing out of certain financial assistance from others, that could not be worked out and it was dropped. Subsequently, my lord, I approached the bank and the OTS proposal has already been taken up. And the bank has assured me, lord, that within 30 days the entire amount could be settled and the matter would be resolved. The only problem, my lord, is in the bank has preferred a Section 7 application before the NCLT as a financial creditor notes. And the NCLT has admitted the matter and has appointed an IPR, interim resolution professional notes. And problem, my lord, is now the interim, as per the orders of the NCLT, the interim resolution professional is to take over possession of the property notes. So once the possession goes, my lord, the banks will not be in a position to entertain my OTS application. So at best, my lord, within 30 days, because banks are interested, my lords, for the money, including interest, which I have borrowed from them, my lords.
So you have already received notice from
NCL.
NCL.
I have already received notice, my lord,
So
and I have filed an application,
here,
3 applications before the NCLT were filed, my lords. And if your lordship would kindly see the NCLT's order.
any of the application filed by you, you must have mentioned that.
I have mentioned it. And I have also said that since the intermediate resolution professional has already taken up symbolic possession by operation of law, let there be an inventory and a videography of the entire assets. Because ultimately, my lord, if these assets go waste, my lord, because the bank will be trying to maximize its recovery, my lords. It will be in no one's interest, my lord, if the recovery will be made and if the assets.
The relief which you are seeking here by way of an interim application, if you have already filed, and
that was not considered. Like, with great respect, my lord, if your lordship would kindly appreciate,
your application has been rejected.
It was not been rejected. The application, what has happened was 3 applications were filed. One by the financial creditor. If your lordship would kindly see, if your lordship would kindly take up note that annexure 18 at page 172, my lords. And there were 3 applications filed. There were 3 applications filed at the left-hand side, sorry, at the right-hand side, your lordship would appreciate. One was IA 98. The second one was IA 177, which was my application, my lords. And the third one was IA 187.
Which is your
my application was IA 177. And
why you have filed that in?
Well, I have filed that is as annexion 9 at page 112, my lords. Unfortunately, my lord, if your lordship would kindly take up the operating portion, my lord, operating portion at page 174 of that order, they dispose of IA 187, which was filed by the bank. They keep in the bank's IA 98 and also my application under IA 177. That your lordship will get it at 174, running page 174, running page 3 of the NCLT's order notes. And so far as my IA 177, my lord, is concerned, the lordship will kindly turn to annexion 9 at page 112, my lords.
No, this, you see, your interim application has been posted to 22/8/2024.
What has happened with the alliance of the application of the interim resolution professional, lord?
So maybe that on that day you were not there to praise that interim application.
So that
Nobody appeared.
So, but and the authority has already power, no?
Sorry,
they can dispose it off.
No, they have not, lord. With great respect, my instructions.
No, they have the power to dispose it off.
They have the power to dispose of, but
we will interfere at
it's you lordship will kindly see it's a basic petition where the stakes are high and where the petitioners and the lord are ready and willing to pay the entire amount of the bank.
That you say before him, if you do not appear on the date fixed or application, that is the exact reason why it was added to 20/8, and we do not know what happened on 20/8.
22.
Matter for consideration.
I bow down. So, but unfortunately, 5C communication gap, that is a lot. 226 discretion and
you do not know.
Second round.
You are already one authority, competent authority, in session over the matter. You have already approached the authority. You have filed an interim application for appropriate relief. When the matter was called, you were not there. The case was adjourned to another date. You have no instruction for that. This court at this stage, my petition will interfere. What do you expect from us?
Let the entire thing be kept in abeyance for 30 days. Let the bank appear. I take notice as special as
you can very well make before that.
Canada Bank.
It is there.
So since my learned friend was also appearing for the bank.
My instructions are this petition is not maintainable. This is a second round of.
The earlier was disposed of.
This I-177.
It is pending.
It is pending. You pursue that, Mr.
Yes, I just humbly pray, Lord. In the meantime,
before your lordships today being made, that my IA 177 was not considered. All those things was considered in the previous round of writ petition before.
Once this IA number 177 is disposed of, in any such application has been made previously dealt, that NCLT can consider, but because application is pending there, we can.
I just want to claim the lordship may fix any day next week, my lords. I'll appear before the NCLT.
Then we fix it. The date was already there.
Or at least let them.
It must have been fixed by after 28th. What date has been
Because
fixed?
the council, you are supposed to know what date it was fixed.
So, lordship, kindly give me a minute. So, lordship, I'm sorry, lordship, kindly give me a minute.
That must have been fixed.
It must have been.
Yes, it is there.
Could you know at least?
No.
So you can prepone it by mentioning
application.
Application because of the.
I got onto that. I'll file an application. But in the meantime, the interim resolution professional takes over, my lord. Then the stage, my lordship knows that this NCLT proceeding, your lordship knows, has several stages, my lords. Once they cross over to another stage, in spite of the fact that I pay this entire amount.
You are at laches. You do not.
No, I got on.
Seeking relief from another court.
I got on.
Petition has been.
I'm against a very difficult case.
After going to the order dated so and so, it appears that the petitioner's application, that is IN number so and so, was adjourned for further consideration on 22/8/2024. As no one appeared to press this application. It is stated by the Land and Council appearing
Opposite but not three.
Opposite party number 3 in Mr. Acharya.
All the parties.
All the opposite party.
Except, I'm sorry, SP and collector भी अच्छे plus 1, 2, 3 and 8.
1, 2, 3 and 8. Submits that IA bracket 1B number 8 of page number देखिए देखो 174 में mention है IA 1B number 177 CB oblique 2023 is now posted to Quebec 29/2024 for consideration. The Land and Council for the petitioner submits that some interim relief may be granted so that till the decision is taken by the NCLT, the petitioner's interest might not be affected, since the one authority is in session over the matter and interim application has been filed for seeking some relief, and the petitioner can very well file an advance petition to move such application. We are not inclined to pass any order, and we are not expressing any view on the prayer made here. Accordingly, the writ petition is disposed of.
One small indulgence note. Page 174 for a minute, that lordship would see. Now the NCLT has directed the police to take over. The lordship may kindly turn to 174 minutes. Unnumbered paragraph 2 minutes, 4 lines from the bottom minutes of unnumbered paragraph 2. Accordingly, lordship got it minutes?
Is that we will take over the power of the NCLT at this stage of this.
Just add for the so submits that the NCLT, while disposing of the IA number so and so, has directed the respondents number 1, 2, 3 to provide required police assistance to the RP. RP means
resolution professional,
who is entitled to take custody
in taking over the custody and control over the plant premises of the corporate debtor situated at Kapur Singh and Pihura Mouza, Atgad, Katak, Odisha. Land Council, it is up to him to move an application in advance. Yes, next.
At least this action may be temporarily, at least for some time, to enable me to move that application.
What they have done,
otherwise, direction. No, we are not entering into all these things. You said that earlier approach, all these that we once the session, if we express any line of it,
this is not proceed.
If that works, aspect note, one small indulgence from the lordship's note. I'll move an application for advancing the next week.
We have said that.
No, you're not
you can file an application for advancing the
Let that be favorably considered, my lords.
favorably the same shall be considered in accordance with
the entire property goes to waste. Now, once the IPR is
advance petition file kale kon କରାଯିବ ତାଙ୍କୁ ଗୋଟେ copy ଦେବେ ସେ ଲୋକ available ଥିବା ଦରକାର ବା virtual mode ରେ
since my learned friend is appearing, since my learned friend is appearing,
functioning only on 2 days.
since my learned friend is already appearing, my lords.
ସେ କୋଉ ଦିନ ବସୁ he is right କୋଉ ଦିନ ତାଙ୍କର ସିଟିଂ ଥିବ ଏ ସବୁ ବିଭିନ୍ନ ଜିନିଷ ରହୁଛି ଆମେ ଏଠି order ଟେ ପାସ୍ କରିଦବୁ ସେ ନଥିବେ ସେ କୋର୍ଟ ଫଙ୍କସନ କରୁନଥିବ all right next
No, at least not when they take over possession, the entire proceeding will be videotaped so that at least my property is ensured, my lords. Simply to set the direction kindly.
they are be taken in accordance with law they will definitely
No, they are not doing it, my lords. At least one word from the lordship would
anticipate that they will not do and if they do it anything in accordance not in accordance with law you have the forum the remedy to now at this stage cannot anticipate something to happen and pass an order.
My presence.
Make the prayer before the appropriate authority. Yes, next. Said that
professional may consider my prayer for an inventory.
Said that the interim application has
by virtue of this application.
Yes, next.
Item 73.
Item 70.
May I please your lordship?
73.
May I please your lordship? My lord, I have filed this modification of order dated 12/8/2024 passed in WPC number 18725/24 by this honorable court. My lord, according to that order, your lordship has directed to dispose directed to the opposite party number 2, who is Assistant Settlement Officer Jobra Kotak, to take a fresh decision in accordance with law. My lord, when the petitioner with the order went to OP number 2, he refused to accept the same as he has no jurisdiction to enter on that because that Moja has been transferred to Puri and the OP number 4 has the jurisdiction to entertain that. Who is Additional Sub-Collector Settlement Puri, your lordship?
Here?
As Additional Sub-Collector Settlement Puri. Who is OP number 4, my lordship?
So you want that instead of that
instead of OP number
OP
2?
number 2, it should be OP number 4.
Yes, your lordship.
That is your prayer.
Yes, my lordship.
IN number so and so. There is an application for modification of the order dated 12/8/2024. The Land Council for the petitioner submits that while disposing of the writ petition, direction was issued to Assistant Settlement Officer Jobra Cutter, opposite party number 2, to take a fresh decision in accordance with law in terms of the judgment pronounced by this court in WPC number 1608 of 2014 and batch. If the case of the petitioners is covered by the said judgment, Land Council submits that when the petitioners approached opposite party number 2, it was intimated to them that in fact opposite party number 4, that is Additional Sub-Collector Puri, a jurisdiction to consider the case of the petitioners, and therefore in place of opposite party number 2, opposite party number 4 may be directed to take the fresh decision. And since time stipulated in the aforesaid order dated 12/8/2024 has expired, the time to expire कर जाइए Extension कौन टाइम मांगी
extension of time to approach before the additional sub-collector.
Have you fixed any time to in the case petition
Upon filing the certified
within
copy,
a period
3
of
months
2 weeks from
will be
today? All right. The time stipulated therein may be extended. The Land Council for the state has no objection, considering the submission made by the Land Council also. The order dated 12/8/2024 is modified to the extent that in case the petitioners produce the copy of the order dated 12/8/2024, so also the order passed today before the opposite party number 4, along with the judgment passed by the division bench of this court in WPC number 1608 of 2014, within a period of 2 weeks from today. On receipt of the same, opposite party number 4 shall adjudicate the matter in accordance with law and communicate the order to the petitioners within 3 months from the date of such adjudication. Interim application is accordingly disposed of. Yes.
Obliged, Your Lordship.
Item 74.
There were some password matters, but actually, hearing password.
Passover item number 11.
My please, Lordship, on the last occasion, Your Lordship, I have given 2 judgments of this honorable court where my matter is covered. One is relating to my matter, a portion of the land where in the case of Paramananda Ramakrishna Mishra versus State of Odisha, WPC number 24,769 of 2014.
Wait. There is why the order under Annexure 4 shall not be quashed and direction shall not be issued to the opposite party number 2 to record all ROR under Annexure 5 in favor of the petitioner. And if opposite party number 1 to 4 fail to show cause or shows insufficient cause, then the said will be made absolute, quashing Annexure 4. And the further direction to OP number 2 to record the HAL ROR in Annexure 5 within a month. Okay, so Annexure 4 is the
order of the ASO, and this honorable court in the case of Narottam Ratha versus State of Odisha.
Para 12.
My lord, and the connected matter relating to the same plot, my lord. Portion of the plot was
okay. The very good judgment.
My lord, that Ramakrishna Mishra versus State of Odisha.
Copy
already given. Copy both them.
Annexion. Annexing.
So that original order is Narottam
Ratha. Basing on that judgment, this judgment.
The petitioner has C.DASH has prayed for quashing Annexure 4, which is the final order passed by the opposite party number 4, na?
My lord.
Opposite party number 4, assistant settlement officer in
Objection
case number, what is the objection?
13419.
13419 of 2013. The London Council for the petitioner submitted that the division bench of this court in the case of Narottam Rath versus State of Odisha and batch case that is in WPC number so and so 1608 and has already decided the matter and it is a covered case. The Learning Council for the state, after going through the averments in the writ petition, so also the decision of this court in the case of Narottam Ratho also agrees with the submission made by the Learning Council for the petitioner. Considering the submission made by the Land Council for the parties, this case is disposed of in terms of the order passed in the case of Narottam Ratho versus State of Orissa, and that is all that there is, and that is to be set aside. So, बाकी जो order अच्छी देखी लिखते हैं.
My lord,
This operative part is to be inserted. Rather, लिखा your operative part which is your case.
1, 2, 3, 4.
All right.
Both the cases same.
Yes.
Obliged, ma'am.
Item 13.
And with
what?
My lord, this matter was yesterday, I taken instruction from the bank, in terms of the earlier order, party has deposited 5 lakhs, but he has not submitted any OTS proposal on that day. Thereafter, but he has given a proposal on 5th August 2024, that is at page number 18.
5th August 2024.
Milord, page number 18, he has given a proposal, but there is no offer letter. Offer amount must be indicated in this letter. Well, simply after that,
Annexure 5.
Annexure 4. Huh?
Annexure 4, page 18.
1-4 is not that. Item 1-4 is OA order.
Is it that?
114 only. 14 is a way order.
1-4.
No.
Sorry, I meant excuse me. Keep in mind 40 will place.
Huh? 1-4 is regarding OA order.
1-4 is Hemant Kumar Rao. No, the council is Hemant Kumar Rao, P.S. Das. So, non-appears for urgent purpose.
Item 16.
Huh?
Yes, 16.
16, it was of a sergeant, Mr. Kaushik Anand Guru.
Is this?
I have filed a IA 11524 for amendment.
Let us come. We asked to bring that amendment on record. Whether that IA has come. 11524 of 2024. It is also there. Yes. What amendment you want?
To delete the opposite part number 2 and to
amendment in the cost title of these ones.
the competent authority, GAIL India. That my representation under annexure 4 is pending before this project officer, competent authority of Odisha, GAIL Limited, Bhubaneswar. Page 25.
In case of opposite party number 2, GAIL India Limited, this should be incorporated.
Yes, my lord. Totally deleted and competent authority.
Odisha, Mumbai, Nagpur, Jharsuguda gas pipeline.
Yes, my lord.
That is to be inserted.
That is to be inserted.
IA number 11524 of 2024. This is an application for amendment of the statute of the writ petition. The Land Council submits that GAIL India Limited has been inadvertently mentioned as opposite party number 2. In fact, the Court of competent authority bracket Odisha, Mumbai, Nagpur, Jharsuguda, gas pipeline, GAIL, so on so on is the competent authority, and therefore, in case of GAIL India so the name of so be incorporated in the cost act. The land council, nobody is appearing, na? Union of India.
Last time that appeared, my lord.
तो आज कहले नि आपण मूव करिए बोली सी हुए तो ये नाहाती यूनियन ऑफ इंडिया ऑफिस ऑफ अच्छी ये अच्छा
No, not necessary.
ये रेसिडेंट Mr. Padi, so one interim application has been filed. Say GAIL India को delete करिए गोटा कौन कोर्ट ऑफ कॉम्पिटेंट अथॉरिटी ओडिशा मुंबई नागपुर झारसुगुड़ा पाइपलाइन सी होउछन्ती कॉम्पिटेंट अथॉरिटी से कहउछन तांकर नाटा इंसर्ट करियो से इस पई गोटे अमेंडमेंट फाइल करछन्ती आईएन नंबर 11524 ऑफ 2024 तो
well lordship copy sir if they serve the copy I will go through it
कॉपी साहब
कॉपी सॉल्व कर दीजंती आपको खाली आईएटा रे अमेंडमेंट हबो से दुई जगह रे एटा बसिबो या ना तो
my lord for this reason I have to file objection let them impede
objection
What is the question of objection here?
objection किछि नै मो आपन प्रेजेंस ता नोट करिया पई सेथि पई आपन
lordship pass necessary
all right the Mr. Padi has no objection accordingly in place of so and so the so you file an amended first title and give a copy to the so and so
rightly said that competent authority is the right adjudicating authority for
no that is exactly the reason so you serve it by Tuesday by Tuesday this matter can be taken up thereafter
yes ma'am
after filing of the corrected amended cost title example the matter will be listed yes
along with me Mr. Guchayat is appearing in this case lordship
नाडा पूरा नाडा कौन
Deepak Guchayat
Deepak
Guchayat
CGC Mr. Padi को नाश होइतो तांकर
Item 45.
If 4 may I plead, my lord. Here, my lord, the petitioner has appeared from the preliminary written examination for the post of civil judge in the Odisha Judicial Service, my lord. And thereafter, the answer key was published under Annexure 5. And telling her answer with the answer key corroborated by the OPSC, my lord, the petitioner was scoring the qualifying marks, my lord. In spite of that, the name was not reflected in the result published for the
qualifying mark कितने number
40% minimum is she has scored 44.75 as per her calculation based her assessment based on the answer key provided by the OPSC, my lord.
So this requires a re-evaluation.
For re-evaluation, I have yes, my lord. I have approached the chairman, my lord, of the OPSC. That may kindly be considered, my lord, because I have also provided the table, my lord. The answer.
But what is the rule? What's the rule? Re-evaluation is there.
Per my
in the rule, re-evaluation is there.
Are you sure that the answers which has been given in that OMR answer sets,
yes, my lord,
if
that
it
also
is
I have annexed.
taken into consideration, your mark will be 40 plus.
Yes, my lord. The OMR answer sheet also I have annexed, my lord. That is
no, you want re-action or what?
Yes, my lord, re-evaluation.
Re-evaluation.
The OMR answer sheet is 45.
Considered
At paragraph 10, my lord, page 5, I have specifically pleaded the government, my lord.
No, government needs
page 5, paragraph 10.
Just show the answer sheets which has been provided by the
OPC.
Yes.
OPC is my lord at page annexer 5, page 46. The relevant starts from page 47.
All right. How do
I
you
have been
say?
supplied with booklet series A.
Booklet series A.
Yes, ma'am.
A.
And the answers are there. I've made a for a reference of my lots, my lord. I've made a table, my lord, at annexer 8. I've attempted 56 number of questions, and out of it, I have wrongly answered 9 questions.
50?
I have attempted total 56 number of questions, and I have wrongly answered 9 number of questions.
তাহলে কোন হবে সে 9?
2.25 marks, negative mark.
Negative mark is there.
Negative plus 9 marks because I have answered the total 9 questions. So total it will be 44.75 out of 56. Because not a question set 9 marks in plus 2.25 marks negatives.
କିଏ ଦେଖିବ ଏଠି ଆପଣ କଣ ଆନ୍ସର ଦେଇଥିଲେ କଣ ଭୁଲ ହେଲା କଣ ଠିକ ହେଲା
Score to be 44.75, which is
ଆପଣ ନିଜେ are you satisfied ଯେ calculation ଭୁଲ ହେଇଛି ବୋଲି?
Yes, my lord. Because as
Otherwise
per the table, my lord, the candidate
table ଆଉ ଆପଣଙ୍କର answer sheets ଯୋଉ wrong question ପାଇଁ ଯୋଉ ଅଛି କାଟିବା ପାଇଁ ମାର୍କ ତାକୁ କାଟି ଦେଲା ପରେ ଆପଣଙ୍କର ହଉଛି 40 ପ୍ଲସ୍ ହେଇଯାଉଛି?
Yes, my lord.
କୋଉଠି ଆପଣ ରିପିଟିସନ ରେ ସେମିତି ନେଇଛନ୍ତି ଦେଖିଲେ ଷ୍ଟାଣ୍ଡ?
Page 5, my lord, paragraph 10. The 6th line, my lord.
ପୁରା ଆରମ୍ଭରୁ ପଢନ୍ତୁ.
Yes, ma'am. That the petitioner humbly submits that the petitioner attempted 56 numbers of questions out of total 100 questions. In the advertisement,
ଗୋଟେ ଭୁଲ ଯଦି ଦେବେ ଆପଣ wrong answer ପାଇଁ କେତେ ନମ୍ବର ମାଇନସ ହବ?
2.25.
0.5. 0.25.
0.25.
Yes, my lord.
ଆଚ୍ଛା ଆପଣ ଭୁଲ ଦେଇଛନ୍ତି କେତେଟା?
9ଟା. It is there, my lord.
9ଟା.
Yes, my lord.
So 9 ହେଲେ ଆପଣଙ୍କର କେତେ ହବ କଟିବ?
2.25 in marks along with 9 questions ସେ 9 mark ଟା ବି କଟିବ.
2.25 ହଉଛି ମାର୍କ ଆଉ ସେ 9ଟା କଟିଯିବ.
9ଟା କଟିଯିବ.
9ଟା ହେଲେ ଧର ଆପଣ 56 minus 9 ହେଲେ 14 9 16 9 ଗଲେ 17 47 ନମ୍ବର ହଉଛି. 56 ଆପଣ ଆନ୍ସର ଦେଇଛନ୍ତି.
Yes, my lord.
You mean to say that 9ଟା ଯଦି ଭୁଲ ଆପଣଙ୍କର ରହିଛି ତାହେଲେ ଆପଣଙ୍କର 47 ଟା ଠିକ ଆନ୍ସର ଅଛି ନା କଣ?
47 ଟା ଠିକ ଅଛି, but ସେ ଯୋଉ 9ଟା କଟିବ ସେ 9ଟା ସହିତ each wrong answer ପାଇଁ minus 0.25 marks. That is there in the advertisement, my lord.
47 ରୁ ସେଟା କଟିବ ପରା ପୁଣି?
Yes, my lord. 47 ରୁ ପୁଣି ସେଟା କଟିବ.
2.25 କଟିବ.
Yes, my lord.
2.25 କଟିଲେ ଆପଣଙ୍କର ଆସୁଛି 44.75 ଆସୁଛି.
Yes, my lord.
Your qualification mark ହଉଛି 40.
40.
Yeah, appear କରନ୍ତି ଏମାନଙ୍କ ପାଇଁ.
Learned senior advocate Mr. Kadipta Mahanti. I have also served a copy on him, my lord.
You have served a copy?
Yes, my lord.
କହିଥିଲେ ତାଙ୍କୁ ଆଜି ମ୍ୟାଟର ଟା ଆପଣ?
ଲିଷ୍ଟ ରେ ତ ଅଛି.
ଲିଷ୍ଟ ଅଛି ଏଟା
ତାଙ୍କର ତ ଇଏ ନାହିଁ.
ଡକା ହେଇଛି. मेन एग्जामिनेशन ପାଇଁ ବୋଧେ ଇଏ ହେଇଗଲାଣି. So we'll take up this matter. Can Mr. Mahanti, if you have got the phone number.
I will contact Mr. Mahanti.
Mr. Mahanti को हमें पूछे जो instruction नवा पे ये matter था. We'll list this matter on 10th.
70.
he said that he has already given a copy of the writ petition on Mr. Mahanti. ତେଣୁ ଆପଣ
We haven't received any copy yet. I have given to Pranay Mahanti. ସେ ତ ନିଜେ ରିସିଭ୍ କରିପାରିବେ.
ହଁ ତ ଲେଖନ୍ତୁ the petitioner Gitanjali Sahu has filed this writ petition with following prayers, quote 1 and 2. In paragraph number 10 of the writ petition, it is mentioned as follows, quote paragraph number 10. In support of the stand taken in paragraph number 10, Land Counsel for the petitioner has referred to Annexure 4 and Annexure 5. The Land Counsel for the petitioner submits that since the qualifying mark is 40,
Yes.
and if the correct answer given by the petitioner and the wrong answer given so and so is taken into account, then it would be clear that the petitioner has qualified to appear the next examinations.
To qualify in the preliminary exam.
Qualified the preliminary examination.
To be eligible for the main.
And she is eligible for appearing in the main examination. Mr. P.K. Mahanti used to appear for the opposite party.
OPSC.
The type of OPSC. Land Counsel for the petitioner submits that copy of the writ petition has already been served on Mr. Pranay Mahanti.
Yes, ma'am.
Stop. The associate of the senior advocate is present, and he submits that he will apprise his senior about the contentions raised by the Land Counsel for the petitioner. So let Mr. Mahanti obtain instruction in the matter. The matter be listed on 10th of September 2024, indicating the name of the land senior advocate in the cause. Yes.
Oh, yes, madam.
Item 30.
We see about litigation. The auction which are fixed to 21st August is auction is failed. But
So now you can negotiate with the bank
that
and
is the-
offer the price, whatever it may be. So
here, my lord, the problem is with my respectful submission before the lordship that here the outstanding dues is less than the security value. Security value is 26 lakhs somewhat as per the reserve price. This is the problem.
Anyway, you negotiate.
Value of the security is 26 lakhs.
25 lakhs 66.
Yes, as per page
Page 21.
Page 21. So,
no, Mr. Sahu, since now it has failed, you have got time to take the further steps in accordance with law. So in the meantime, let him appear and the bank is convinced. All right. Petitioner has so has challenged Annexure 5, the cell notice dated 1/8/2024. Sued by the opposite party. Mr. Tunasau Land Counsel appearing for the opposite party submits that the auction which was supposed to be held, which was held on केबे केते तारिख रे हेतला
21st August
21st August
filed due
2024 has failed and it is up to the
non-participation of the bidders.
huh?
Due to non-participation of the
due to non-participation of the bidder. The petitioner can approach the bank authorities for negotiation in view of the submission made by the learned counsel for the bank to dispose of the petition, giving liberty to the petitioner to approach the bank for negotiation. Accordingly, the writ petition is disposed of. Yes, next.
File a petition. File a petition for
Whatever you do, negotiation କରିବାର जो method ଅଛି ଆପଣ ଯିବେ ତା ଭିତରେ ପଶିଲେ ପୁଣି କହିଦେବେ ଆପଣ କାଇଁ entertain କଲେ ଯାହା କରିବା
statement ବି ଦଉନାହାନ୍ତି ଆମକୁ ସେ
no we go
Item 34.
Item 44. This is the here the petitioner. I am for the bank lord. The petitioner has challenged the order passed with the DRT Kolkata, but modifying the order passed with the DRT Kolkata. The DRT Kolkata passed a specific order that order at page 25 is there. So
that order was passed.
That order is the appeal is allowed. Impugned order dated 28th November 2023, passed by the learned DRT Cuttack is set aside. Matter is remanded back to the learned DRT Cuttack to decide the essay number 129 of 2023 along with the IN number 1656 of 2023 with a period of 3 months from today. However, till the matter is taken up by the learned DRT, appellant bank shall not proceed further and shall maintain the status quo in the matter.
No, before the
before the DRT, the auction purchaser has also appeared in this matter, and matter is posted to 27th September 2024.
What do you want now?
Now I am for the bank lord. The petitioner lonely petitioner has come file this writ petition for modifying the order passed by the DRT Kolkata. So if this being the question, he may approach to the DRT Kolkata. Modifying the
what is this prayer?
You are
I am for the bank lord.
Oh, you are
the impugned order. No, the impugned order dated 9/4/24.
ନାହିଁ ଆପଣ ଏତେ କଥା କହିଗଲେ ଆମ କହିଲେ ଆପଣ ପିଟିସନ ଆଚ୍ଛା ଆସନ୍ତୁ କଣ କହିବେ
ଠିକ ଅଛି
yes next pass next week କରିଦିଅ କେତେ number next week କରିଦିଅ
Item 48.
Lord 48 here the auction also failed.
With the council.
Item 48. Approval pass over
option failing upon negotiate କରିବେ bank କେବେ ହବାର ଥିଲା auction
30
ଲେଖି ଦିଅନ୍ତୁ ସେମ୍
30th of August
ଚେଞ୍ଜ ହେବ 30/8 ରେ auction ହେଇଥିଲା ଫେଲ୍ କଲା ସେ ବାକି ତ ବଡ ସେଲ୍ ହେଲା yes
disposal
ପୁନା ସମ ନା ଲେଖିଦେବ
Item 64.
54 64 64 Mr. Lalit Sahu next week person
Item 74.
Item 70, I am the opposite of the CBA inputs. File is not with me.
So what we can do? If you want file, we can provide the pen drive, we can assist you. The registry can supply the file to you. You are for the CDA.
Yes, Your Lordship, on behalf of Mr. Dayamba Mahapatra.
Pen drive टी दियंतु फाइल जदी मिस करछि नै जानतु हला आजि करिवे न से पुनी केस पड़ेबो आपण पाइबे हला so we are passing that order today hela the London Council appearing for the CD submit that since the file has been misplaced the same may be supplied in its pen drive. Let the registry do the needful in case the pen drive is provided by the Planet Council for the CDA. Put up this matter next week. Yes.
Obligation.
Item 75.
75, Lordship, I prefer short adjournment because the brief has been transferred to us for the first time, Lordship.
You are for the petitioner.
After the petitioner filed power, for the my client will hand over the brief to me.
No, your name is not there in the cause list.
Your Lordship, I have filed power. My name reflects in the cause list.
Yes.
But file, my client will bring and hand over today by the evening.
वकालतनामाटी ଦେଇଛନ୍ତି ଫାଇଲ ଦେଇନାହାନ୍ତି
ଆଜ୍ଞା
okay you want it to when
17 କୁ ଆସିବ
all right the Planet Council for the petition of 6 for an adjournment for a week place this matter on 17 September 2024 all right
Item 76.
I am for the petitioner. Item 76, I am for the opposite party. Mr. Tushar Mehta is appearing on behalf of the opposite partner 1 and 2. Today he has a personal difficulty. Let it come on 9th.
The 9th, next week, Mr. Ashok Mahanti, senior advocate, is appearing also. He was there. He's now on his legs in Chief Justice Court. Next week, he has some problem, my lord.
9th is
a holiday.
Holiday.
Well, may I pray next week, my lord? We commence in 17th.
Yes, 17, my lord. This is the memo of affairs.
Senior advocate Ashok.
Mr. Mohanty will appear for the
petitioner. Earlier, that order was there, my lord. But somehow the noting is
filing the appearance memo today, so we are
yes. So that was perhaps missed.
All right.
So there is a noting.
The memorandum of appearance is filed by the senior advocate. And Mr. Ashok Mahabali, which is taken under submission was made by the Land Council for the opposite party.
1 and 2.
MCL.
1 and 2. That Mr. Tushar Mehta, senior advocate, appear.
He has already appeared.
He has already appeared.
Yes.
And address this for them for opposite party number 1 and the matter may be taken up in the week commencing from 17 September 2020. On consensus of the parties, this matter on 17th of September 2020.
We commence 17.
We commence.
Interim order to continue.
Interim order there?
Yes.
Interim order to continue.
Item 77.
My lord, item 77.
Item 77. I feel that the petition commence on 17th, my lord. Item 77, your signal. I pray that.
Yes, Mr. Padi, what do you say?
Yes, Navodaya Vidyalaya Samiti.
It's all right. Mr. Joshi wants adjournment till 17.
Yes, ma'am.
All right. Mr. Joshi, Land Council for the petition on 6 for an adjournment till 17. Mr. Padi, Land Council for the Union of India as Solicitor General has no objection. It is matter commencing on 17 September 2020. Yes, next.
Along with me, Jyotsna Sahu is appearing.
Jyotsna Sahu, along with CGC, Jyotsna Sahu.
Item 78.
And it is to be registered with the second item, WPC number 18550/2017. Yes, item 78.
78, I am for the petitioner, my lord. Due to personal difficulties, the conducting counsel is not present today, my lord.
What adjournment?
Adjournment.
To next week or?
Yes, next week.
All right. Mention is made on behalf of Mr. Devan Sismananda for adjournment till next week. This matters on 10th of September 2024. Yes.
Item 79.
79, I am for the respondents.
Santosh Kumar Patnaik.
No, Mr.
Amitabh
Tripathi is
Tripathi.
appearing now. Amitabh Tripathi. Amitabh Tripathi, he was
We are just passing it over. He may come, so.
Yes, he was present here.
সেইটাই তো পাস ওভার করছে না, অর্জন করুন। Yes, next.
Item 80.
Thank you very much. S.K.Sahoo was the petitioner, my lord. He was the superintendent of under this registry of this honorable court, who is no more, and substitution already made. Lordship, this is relating to
Substitution has been already allowed.
Allowed.
All right.
Wife and son already.
It's all right. And so that consolidated petition has been filed.
Already filed.
Where is that consolidated petition that I've seen?
First title,
Yes. I'm back for them. Consolidated cost title consolidated cost title. Cost title the file करिए जो incorporating the names of wife and son कौन परा वहीं से डर नहीं तो किबे फाइल करें
the file on 11/12/2019.
Tenth July, 23 रुपए लीजिए.
7/12/19.
अच्छा, all right. Padmini Sahu and
son Sukumar Dev.
Jaydev
Sahu.
All right. What is the prayer made in this writ petition?
Actually, while in service, he suffered from
medical bill.
Obstructive jaundice. He was from the office. He was admitted in SCV Medical College. That I have stated in paragraph 4, paragraph 3.1 of page 4 of the writ petition. While he was under treatment, due to seriousness, he was taken to Tata Memorial Cancer Institute, Mayur. They requested for referrals, but due to illness seriousness, he was moved to the Tata Memorial Center, and there he was operated.
So you must have submitted your bills before the
bills, my lord.
What has been held?
My lord, your lordship kindly turn to annexure 3, page 27.
It's not legible.
This is the DMT. They sought for the requested to furnish the treatment records and final bills.
Yes.
Lordship kindly turn to page 28, annexure 4. This registry of this office, special officer made the
post-factor referral.
My lord, requested for post-factor referral and along with all the records, medical records, my lord. Lordship kindly see page 52, annexure 5. Page 52. Only they have reimbursed 39,000 something.
ଆପଣ ବିଲ୍ ଟୋଟାଲ ଆମାଉଣ୍ଟ କେତେ ଥିଲା?
5 lakhs.
କାଉଣ୍ଟରରେ କଣ କହୁଛନ୍ତି?
କାଉଣ୍ଟରରେ କହୁଛନ୍ତି ଯେ ସେ 14 ମସିହାରୁ ପୋଷ୍ଟ ଫ୍ୟାକ୍ଟର ରେଫରାଲଟା ଆଉ ନାହିଁ, but your lordship kindly see the counter filed by this registry at page internal page 2. Counter filed by the opposite part number 5. Page 2, madam. The second paragraph 6. The middle of the paragraph. But for such treatment in referral hospital, prior permission of the para 6 middle. Middle.
The expenditure in court.
But for such treatment in referral hospital, prior permission of the state government is required.
Further, in case of emergency, if treatment is made in referral hospital post facto permission of the DMT, government or DMT is required for reimbursement of the amount as per the government order. So, your lordship kindly see the last order 25/8/2023 passed by this honorable court, order number 12. The government is to take the instruction in this regard.
Yes, Mr. Mishra.
My lord. Madam, I've already seen the counter of the registry map of this honorable court. Now, may I take, my lord, the counter of the opposite party 1 and 2?
39,330 ଟଙ୍କା ତାଙ୍କୁ ଦଉଛନ୍ତି ସେ ଟାଟା ମେମୋରିଆଲ ଯାଇକିନି ଚିକିତ୍ସା ହେଇକିନି ମରିକିନି.
And once it was already referred.
Yes.
Subsequently, because of emergency, could not obtain.
Technical, as my lord should see in the counter of the opposite party 1 and 2, because there was no reference by.
Yes, that is what is.
For a 6 and 7.
No, the thing is that you see, the registry has verified.
Yes.
And after a scrutiny of the documents, the registry found it to be genuine document.
Yes.
And once it is referred on this ground, if you say, then what will happen?
Well, this line is humbly submitted that the treating physician has never advised refer the petitioner in the discharge certificate to any higher. No, this is purely.
ଆପଣ ସେ ଟ୍ରିଟମେଣ୍ଟ ହଉଥିଲା ଏଠି ତ ଆପଣଙ୍କର ହଁ ସୋ ସେମାନେ ରେଫର କଲେ ଟାଟା ମେମୋରିଆଲ କୁ ସେଇ କଣ୍ଡିସନ ରେ
it is humbly submitted that the treating physician has never advised refer the petitioner in the discharge certificate. My lord, I am reading
discharge certificate refer କରି ନାହିଁ ତେଣୁ ସେ କଲେ
to any higher center outside state. The petitioner has gone to Tata Memorial Center, Mumbai for treatment on his own volition without the recommendation of the HOD Surgical Gastroenterology Department.
That we have also stated categorically.
Yes.
We have stated, we have requested to refer the matter because due to serious illness. Your lordship, I have mentioned paragraph 5, page 5, paragraph 3.2.
Being aware about the health condition.
Accordingly, this registry of this honorable court referred the matter post facto referral.
All right. We are reserving the order. The order. All right.
Only thing that earlier occasion, one order of the honorable single judge order that post facto approval has been met and they have paid the money. That
you filed it in annexure?
I have filed that judgment.
Annexure?
That is not annexure.
It's not annexure.
Relying upon. All right, you file it. Annex question, please.
WPC 3431 of 2000. I will accept.
With your lordship's permission, item 79.
It's number
83. 80.
Eight zero. मैं एजुट है बोलना पड़ता
80.
Just one. 79.
সেটা কিন্তু 80 সে
Yes, Mr. कितने नंबर आइटम अपन
79.
79.
Vale.
Standard count
True.
19/4 order, my lord.
ସେ କହିସାରନ୍ତୁ ଆପଣ କହିବେ ଆଗରୁ କଣ କହୁଛନ୍ତି
18, my lord. Order number 18.
Yes.
19/4/2024 order, my lord.
19/4.
My lord.
Yes.
My lord, this Honorable Court has directed us to file a detailed demand of the arrears, my lord. And accordingly, we have filed it, my lord. And on the last occasion, my lord, the senior has taken time to file an affidavit.
Just come to that order and place the relevant portion.
My lord, paragraph 10, my lord.
Yes.
May I read, my lord?
Yes.
In view of the submission advance at the above, it is observed that the appellant corporation in the meanwhile shall be under obligation to make a requisition for funds to the state government for payment of differential salary to the employees erstwhile employee of the corporation based on the revised scale of pay with effect from 1/1/96 under the Odisha revised scale of rules 19. Any observation? Well, accordingly, we have, my lord, made a recommendation to file a detailed what is the fund required for that to give the salary to the since 1/1/96 with a scale of payment. And the government has to.
No, it is there in para 8, Mr. R.N. Mishra.
Manner.
He has submitted that if the OSRTC sends requisition for funds for payment to the employees,
to the corporation,
the differential salary based on revised scale of pay with effect from 1/96 shall consider the same. AGA to answer.
My lords, I have filed an affidavit on 28/24. My lord, kindly
copy
that affidavit.
Copy not found.
Just a minute. 28/24. अच्छा, ये सरोज कुमार महारथी is the
Saroj Kumar Mahan.
Right. So they say that you have not given a copy. Please hand over a copy. What you have stated.
My lord, may I take my lord to annex here? Three annexures. My lord, may kindly come to page 9, please. Page 9 of that affidavit. My lord, sir, page 9.
9.
My lord, this is dated 26/24.
Right.
This is from the government to the General Manager of OSRTC in inviting reference to your letter number 1440 dated 9/5/24 on the above mentioned subject. I am directed to say that necessary clarification regarding fund provision to meet the expenditure towards payment of arrear bills of different categories of the employees of the corporation, that is retired as well as existing employees, has been communicated to the OSRTC by District Department letter number 3141 dated 25/3/24, which may kindly be referred to. Then, my lord,
कौन थे थिला कौन लिखिले आपण
the next page. Page 10.
15/3/20. This 15/3/24.
My lord, actually,
prior to that.
it's wrong. My lord, will see letter number 3141.
That is 15/3/24.
That will be 15/3 actually.
अच्छा जे भूलले नहीं नहीं 15 को 25 ही जाई
हाँ, 15 को 25 ही।
हां पढ़न सेटा बोल
My lord, I am reading from sir. In inviting reference to your letter number dated 4/3/24 on the above mentioned subject, I am directed to say that government is providing necessary financial assistance to the OSRTC for development of infrastructure, procurement of buses and construction, renovation of bus stands, which are source of income for the corporation and to meet their requirement. Moreover, at the time of approval of the proposal of implementation of ORSP Rules 1998 for OSRTC employees, it was clarified by this department that additional financial liabilities on this account shall be borne by the OSRTC out of its own resources, and government shall not extend any financial support for this purpose. Secondly, government shall not be saddled with any financial or legal liabilities on account of revision of pay scale of the OSRTC employees. This clarification condition is reflected in this department letter issued on 16/9/2009, allowing revised pay under ORSP Rules 98 two SRTC employees. Further, ex-STS employees are considered as on deputation to the corporation. Accordingly, their area dues are borne by the state government and bonds are released for payment of their area dues. In view of the above, OSRTC may take steps to meet the expenditure towards payment of area dues of different categories of the employees of the corporation, that is retired as well as existing employees out of their own resources. Now, my lord, as my lords will hear this case, there are two groups of employees. One who were
on deputation and other is of the corporation.
Yes, sir. Those employees were paid. Now the grievance of the rest of the employees were that yes, because we are all one, we have merged into one cadre. So when you have given that, please extend the same benefit to us. So when a demand was made and government on examination of the same matter, government comes out with this clarification that because they were deputed employees, so government had the responsibility, so we paid them. But those employees recruited by the OSRTC, they are to be borne by their own source, from their own source.
OSRTC ବର୍ତ୍ତମାନ ଅଛି ନା ବନ୍ଦ ହେଇଗଲାଣି?
ନାଇଁ ସେଟା ତ ବନ୍ଦ ହେଇ ପୁଣି
ଏଇ ସଂସ୍ଥାଟା ଖୋଲିଥିଲା କିଏ? ମନୁ ଖୋଲି ଦେଇଥିଲେ ନା ଆପଣ ଖୋଲିଥିଲେ?
ନାଇଁ ସେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ
ତ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଖୋଲିଥିଲେ, ଗଭର୍ଣ୍ଣମେଣ୍ଟ ବସ୍ ଚାଲୁଥିଲା, ସେ ତାପରେ ସଂସ୍ଥା ବନ୍ଦ ହେଲା, ସେଇ ତାକୁ ସେମାନେ ଚଲେଇଲେ ବହୁତ ଦିନ ଧରି। ତ ତାଙ୍କର ଏଭଳି ବର୍ତ୍ତମାନ ଅବସ୍ଥା ହେଲାଣି, ଆପଣ ଯଦି ଆର୍ଥିକ ସାହାଯ୍ୟ ନ କରିବେ, କେତେ ତ ମରିଗଲେଣି, ଆଉ କେତେ ସେ କଣ ହବ ସେ? ତାର ତ ଫାଇନାନ୍ସିଆଲ ଲସ୍ ହେଲା, ଇଏ ହେଲା, ସବୁ ହେଲା। ସଂସ୍ଥାଟା ତ ଗଭର୍ଣ୍ଣମେଣ୍ଟର ନା ଅଲ୍ଟିମେଟଲି। ତ ତାଙ୍କୁ କଣ ଛାଡୁଛନ୍ତି ଯେ OSRTC ବର୍ତ୍ତମାନ ସିଏ ତାଙ୍କ କଥା ବୁଝିବେ, ବାକିଆ ପଇସା ଦେବେ?
Actually, when this matter was going on, sir, correct. When this matter was going on, when the proposal was being heard by this honorable court, the petitioners are only very less in number. So had I was in the discussion, but the OSRTC gave the
ବହୁତ ଆସିବେ OSRTC ର, ଆହୁରି ବହୁତ ଥିବେ ଯୋଉମାନେ କି ଫାଇଲ କରିବେ, ଯୋଉମାନେ ଭାବୁଛନ୍ତି କିଛି ଆମେ ସାହାଯ୍ୟ ପାଇବୁନି ବୋଲି, ବୋଧେ ଆହୁରି ଲିଗାଲ ବ୍ୟାଟଲ କୁ ଗଲେ ଆହୁରି ପଇସା ଖର୍ଚ୍ଚ ହବ, ଏମିତି ଚୁପଚାପ ହେଇ ବସିଛନ୍ତି। ତେଣୁ ସେମାନେ କିଛି
ଲୋକ କେସ୍ କରିଥିଲେ, ତାଙ୍କର ଯଦି ପ୍ରପୋଜାଲ ପଠେଇଥାନ୍ତେ ଗୋଟେ କଣ ହେଇଥାନ୍ତା, ସେ ଏକାଥରେ ସମସ୍ତଙ୍କର ପଠେଇଦେଲେ ପୁଣି with arrears.
After that we have revised that.
98 ର କେବଳ ଥିଲା କଥା, ସେମାନେ 98 ପରେ 2006 ଟାକୁ ବି add କରିଦେଲେ। Proposal, my lord will also appreciate that OSRTC also has to be reasonable while giving proposals.
No, when you revised the scale of pay, you had the resources with you.
No,
then
from the very beginning, our stand is that we have no resources to pay the.
Then what is the basis on which you
revised? And that notification, my lord, people also kind of belong to those.
No, but what is the basis on which you revised the scale of pay? You had no source.
Since 2000, that revised scale will be applicable from 2009.
You have misrepresented before your employees?
No,
you had no source?
From 2009 we have given, my lord.
Why? You had these resources with
yes, my lord. 2009 we are paying, my lord.
You are paying?
Yes.
Then OSRTC went on loss.
My lord.
What is the reason why you did not pay thereafter?
My lord,
retrospective
No, my lord. The effect will be from 2009.
Exactly.
And it is they are claiming from 1196.
Obviously, because
my lord, two set of employees. We rejected all the application. Those person who are come from the STA, my lord. And for
STA they will take you.
My lord, they are in the notification that is also there, my lord. That all the employees.
So you forget about STA. You tell about your employees.
If that is our stand, my lord. We have no source. We are from 2009. We are paying it. 96 to 2009. We have no source. At that time, the corporation has financial crisis.
So you utilize the services of the employees and you are not paying. So what is the way out? Let there be a prosecution and be behind bar. It will not pay this. You have utilized their services.
We have paid, man, but not at par with the government service.
To come to the operative part of the judgment of the Honorable Single Judge.
Madam.
In that conclusion part, page number 24.
Madam. The petitioner in the respective lead petition have prayed for payment of dues under OSRP Rule 1998 and pay the revised DA at the rate of 148% as are applicable to the employee of the corporation at the relevant time of retirement and consequently payment of differential amount thereto. Next, it has been already held in the above paragraphs that the petitioner entitled to pay under OSRP rules 1998 and thus consequently DA would be available on such refixation of the pay to the employee of the state government. Only fee has been taken by Mr. Mohanty, learned senior advocate for the corporation, that financial condition of the corporation is not good to sanction such arrears salary. There is no proof filed by the corporation as to financial condition of corporation to have been deplored or to meet the entitlement of the petitioner. A false assertion is not enough to diffuse the anxiety of the petitioner. The corporation may be public sector only, but it has to meet the constitutional mandate as available to the employee of the corporation.
Ultimately, what direction was issued?
Last, madam, 26, madam.
Yes, that is the opposite party corporation is directed to issue a modification so and so. Is directed to calculate the differential salary of the petitioners with effect from so and so. And so এই जो माने रिट पिटिशन फाइल करथिले सेमानकर टोटल जदी दिया जाय केते होची तांकर एरियर सैलरी
Exactly.
कैलकुलेशन केते
That should have been the recommendation. Yes.
My lord, as per the my lord, 67 crores, man.
कौन अपन मिथिंग माथि दउछन
नहीं my lord, retired and existing corporation
जो माने फाइल करिसंती रिट पिटिशन सेही मानको केवल डायरेक्शन हेतला नॉट दैट ऑल द क्वेश्चन होची व्हाट मिस्टर मिश्रा पॉइंटिंग आउट जे आपण सेति पर्टिकुलर हिसाब करंतु आपण पूरा
बानारे सब नहीं गले
समस्त पूरा तेणु सेति हिसाब करी केते होची कहंतु
well also may grant 2 weeks time I will file the detail of these employees.
Whenever the order has been passed, the order is very clear. The opposite party corporation is directed to calculate the differential area salary of the petitioners. ये जो केतोड़ा केस है 8-10टा केस की 12टा केस सेतिकिरो केवल आपन को आइतला आपन 67 crores माने कोन
नेमु
एई मानकर रिट पिटिशन अनुଯାयी देखि दियंते एटा होची रिट पिटिशन सुआंसो ना होची एया तार एथि होची एरियर सैलरी एम दी हिसाब करी गोटे दियो then we'll pass some order, we'll see that the Land Council for the state has filed an affidavit on behalf of the respondent number 2 as per the order dated 19/4/2024. Mr. Mishra, Land Council submits that the order passed by the Land Single Judge is very clear to the extent that 4 page version.
Page 24, man. Page 24, 25.
Single Judge for order.
Paragraph 28, man. Single Judge order 26. 26.
20. Order is very clear. It is page 26 of quote for the opposite party number 3 is one. Without calculating the same, now the demand has been made by the corporation for all the employees. At this stage, Mr. Tripathi, Land Council appearing for the petitioner, submits that the matter may be taken up after 2 weeks so that he will prepare a chart indicating the number of the writ petition, the name of the petitioner in that writ petition, the arrear salary which is to be paid to that petitioner, public petitioners. And he will hand over a copy to the Land Council for the state in the meantime. In view of such submission, this matter in the commencing from 30th September 2020. All right. You are appearing for whom?
I am respondent.
Respondent made a copy of the affidavit filed by the respondent number 2 be handed over to the Land Council for the
Appellant and respondent.
Land Council for the appellant and so also the Land Council for the
Oh, bless.